So, welcome to Chapter 17 of the textbook. I'm going to be going over Schedule J, which is the expenses. As I've been advocating now for a while, make sure you're looking at the bankruptcy petition at the same time as you're watching this video. That way you can see the specific areas that I'm talking about, all right? But with Schedule J, we're going to be talking about means testing is going to be referenced and also comparing income to expenses to make sure that we understand which chapter in bankruptcy the client is going to follow, all right? Any questions or comments, as always, please post them in the comment section below. I look forward to your comments. Take care, and I'll see you now with the PowerPoints. So welcome to Chapter 17. As you can see here, Chapter 17 is going to focus on the expenses when it comes to the bankruptcy petition. So coincidentally, I just finished teaching a class a few minutes ago, and I was going exactly over this section. I should have finished this section a long time ago. I'm way behind on the PowerPoint, so I do apologize for that. But I got the momentum going, so I'm ready to go forward with discussing all the issues you might face when it comes to dealing with the expenses. Now, like I just told my class, bankruptcy is not just did we pass the means test, and we'll get to the means test. Be patient. Remember, the means test is looking at the last 6 months of income. That's just part one. It's very possible that you pass the means test, but if we're looking at Schedule I is easy because it's income versus Schedule J. If there's too much disposable income, means test doesn't mean much of anything because we already know $500 a month, we're going to push this case to a Chapter 13. There is no choice. And may not even be worth it for the client to even file bankruptcy if they have that much disposable income. So we don't not only have to look at the exemptions, what is protected, because if certain there's equity, say too much equity in the car, as much as the client qualifies with disposable income, comparing Schedule I to J, and maybe even passing the means test, there's too much equity. They have no choice but to go back to Chapter 13. So it's not just only focusing on the means test. It's comparing Schedule I income versus expenses on Schedule J. So let's just put here income and expenses. And then also, what about the exemptions? So it's just so many things that we have to look at. But that's the mistake that a lot of times pro se debtors make. They say, well, I'm below the means test. I'm done. I'm filing for Chapter 7. And then they realize they have all these equity issues. And then there's a big problem when the trustee says, I want to have your car. So we have to look at all those issues before we can jump to the conclusion of what we're going to do. Now, when it comes to Schedule J on the petition, household size is important. Um, 2 kids living in the house is going to be higher household expenses than no kids or 1 kid. So it's important to include what the size of the household is, especially because the bigger the household, the more that's going to increase the figures on the means test. So when you go to the means test, you're going to see there's a section there where it says how many people in the household. When you put 1, you're going to see one set of numbers. When you put 5, you're going to see a different set of numbers. So that's why the means test is not even just looking at the last 6 months of income, because maybe the client doesn't pass the means test because their income's $2,000 or $3,000 over. But once you include a spouse and 2 dependents, 2 children, those numbers change drastically, and all of a sudden the client does qualify. So keep all those things in mind. Now, marital status. You're going to see clients say this all the time, but my spouse isn't filing for bankruptcy. Doesn't matter. They're part of the household, aren't they? We have to include them. Their income is going to be included, but their expenses too. Again, 2 people living in the house. Me and my wife obviously is costing more money for 2 of us to live in a house versus 1. My food would be my grocery bills would be less. I wouldn't have 2 cars, 2 forms, 2 different insurance listing 2 cars. So it does add up. So make sure that everyone's included. If someone is living there and, even if it's temporarily, they're whatever the situation might be, only for the next 6 months, that has to get included as well. Not only because they might be contributing financially, but also because there will be those additional expenses. Now, as we get older, I never claimed my parents as a dependent on my tax return, but a lot of times clients do claim they have dependents. Where is the proof of that? I ask and I say focus on that issue because People cheat on their taxes. I know. Really? Yeah, yeah, they do. And so the issue is, you know, is this person, yeah, it could be an issue where I have clients say, well, I put them on the tax returns. I'm like, where's the money going? Money's going to another country. I'm like, yeah, this could be an issue with the trustee. You're sending $300 every month to whatever Latin American country. I'm sorry, this is going to be an issue with the trustee. The first place, there's no way to prove that. And two, it's just too much money. It's not a legitimate expense. It's probably going to result in an objection from the trustee. The other problem is they claim their parents are dependents, and they're really not. Their parents are okay financially. There's no proof that any payments have been made. There's no bank accounts, nothing showing that the client is paying for something. Again, it's common. I paid for expenses for my parents. I didn't include them, but it was well documented because I can show how certain expenses were being paid by me. So you have to look at that when they have on the tax returns. They're going to have dependents, the children. Okay, that's normal. But if you see that they're adding adults, then dig deep into that. Make sure that that is really the case. They're not just looking to get a bigger tax refund. And make sure that the numbers are not exaggerated. If they're not listed as a dependent, make sure that the money's going to the right place, and this can be proven. You don't want a situation, like I said, where money's going out of the country. This is going to create more problems that it fixes. Now, when it comes to the household expenses, you're going to see the petition has everything listed there, from car payments, taxes, home maintenance like landscaping. All that is going to be included. But the issues I want you to focus on, and rent, you're going to see how that's an issue with insurance in a few minutes. But the mortgage, is this escrowed? What does escrow mean? It means that the bank is taking the payments for the taxes and the insurance as well. That is the norm these days. I don't know why anybody would not escrow, because no one ever prepares financially when the county says, hey, by the way, the taxes are $2,500. We need the money by yesterday. So escrow is important. I think it protects us all financially, but doesn't mean that a client may not. It's possible they're not escrowed. Just make sure, and make sure they're up to date on those payments as well. Okay. Now, with the second mortgage, my issues with that is very simple. When you're going through either the credit report or you're going through the petition and they do have a second mortgage listed, what happened to the money? That's the question you have to ask the client. When they tell you I have a second mortgage, but I took out the money 5 years ago, then nobody really cares. But you got to ask, where's the money? For all we know, $20,000 were put into a CD account or some sort of investment. I don't care what it is, cryptocurrency. And now all of a sudden, that money's not going to be protected. 9 out of 10 times, the second mortgage, usually just to pay off credit cards. And again, that's an issue too. Okay, you refinance, so you took out a second mortgage. A HELOC, home equity line of credit, is considered a second mortgage. Clients seem to not believe that, but it's true. It's secured to their house, so it works as a second mortgage. They just use a different name on it, probably for advertising purposes, I would say. But when they took out that second mortgage and they paid off their credit cards, what happened then? Are we back to considering a bankruptcy because the credit cards have been all jacked up and maxed out again? If so, what was the time frame? So if someone took out a second mortgage 12 months ago and now they're coming, for 30,000. So let's say this is what they took out, and then today they owe 20,000 12 months later in credit cards. What's going on here? You have to look into that. Not only is a trustee going to ask, there could be fraudulent issues, right? There could be issues with just the client is preparing for bankruptcy and said, let me just I'm going to file it anyway. Let me, jack up my credit cards. But there's also issues of expenses. Why does a client continue to get into, we're talking $50,000 in a 12-month period? How do we get there? This might be a sign of something bigger, such as maybe the client needs to file Chapter 13 and pay this back because the trustee is going to object. Really depends on the facts of the case. I can tell you, as always, the general rule that I tell clients is the more time that has passed by, the less it's an issue. 1 year later, it's an issue. 2 years later, less of an issue. 3, even less. There's no magical timeline. It's just basically based on experience and knowing the trustees in that area. Now, I mentioned household expenses include everybody. Children cost money. I guess I don't have any children, but I'm going based on what everyone else tells me. But they are expensive. There's no getting around that. And so everything has to be included as well. Daycare expenses, educational expenses. Some schools require uniforms. There's books to buy, laptops, all these things we have to do. But what I want to make sure is if that expense is too high every month, make sure the child's not in a private school. There is no law that says a trustee is obligated to let you keep a child in a private school. That is not obligatory. There's no law. We have a public school system, and the trustee is going to say, instead of those $400 going a month to whatever school, that money's coming to me from now on. So make sure. I've had to sometimes reject clients when I find out that their expense includes a private school. It's just not included. It's not included in divorce cases too, unless we're talking clients that have substantial wealth, where it doesn't really affect them. But if it's your typical middle class income family, that child's not going to stay in private school unless somehow the parents can figure out those expenses. Now, when it comes to medical expenses, remember this is what you pay every month to make sure you have insurance, but then you have the out of pocket. And the out of pocket, make sure that you have receipts. Clients, again, sometimes exaggerate and says, don't I have $400 a month in out of pocket? No, you had $400 last month out of pocket. That is not the norm. That's what clients do all the time, even with landscaping. Oh, I spend $400 a month in landscaping. No, you spent $400 last month because you bought it two new palm trees and put mulch all around the house and it looks great, but that's not what you spend every month. This will get divided by 12 months and then that's the magical number. So it's the same thing with medical bills. Make sure there are receipts. There are clients, and that's why I put there, it helps reduce the disposable income when comparing I to J, because I've had clients who have health issues, and that's probably the reason they're filing for bankruptcy. But also, those expenses start to add up. All the copays and everything else could, easily be a couple $100. And one thing is, I've sometimes seen clients pay for that in cash. That's okay, but they should have receipts. Have receipts. So when a trustee says, "What do you mean you have $300 a month in out of pocket medical expenses?" They'll probably say quickly what their medical issues and conditions are, and that's fine. That's excuse me. That would show proof of what's going on, but it also could lead to other issues such as higher. I've had clients who, because of their health, also have higher grocery bills than normal, but they are stuck on a vegetarian diet or eating certain health foods. And the fact is, healthy food is more expensive than not healthy food or junk food. So that does give the opportunity to increase expenses. I think in the past I said, another example, eating out. I've had clients who eat out too much. $500 is not going to be approved by any trustee, but also have clients who are cops. And cops don't go home to eat. They can't. They're not going to go back to the station to eat. They have to eat out on the road, and that's going to increase their expenses. So those are good ways to increase disposable income and decrease that gap between Schedule I and Schedule J. Now, I do want you to focus on, why are there medical bills? Make sure that it's not an issue where there was a car accident and that's why there's medical bills. Because if it's a car accident, then the next question is, who is the client? The plaintiff or the respondent? By the plaintiff, I mean they filed a lawsuit to collect money, go to the lawyer, the personal injury lawyer, and everything else. That results in potential money that belongs to the bankruptcy estate. And that's when the trustee says at the hearing, keep going doing your treatment. I need the information for the personal injury lawyer, because whatever money was going to go to the client now belongs to the bankruptcy estate. So make sure which side they're on. If they're on this side, the respondent, then you're good. That just means that they caused the traffic accident. They're the ones getting sued, and that debt will be listed to wipe out that debt, because that is unsecured debt. If it doesn't, eventually the client's insurance is going to get suspended. Eventually, the driver's license is going to get suspended, and then it's going to get worse for the client. So just make sure which side of the aisle the client falls on, plaintiff or respondent or defendant. All right. Now, I've had clients who do have charitable donations. Again, is the number consistent, or it was increased that month just to make sure that their disposable income was lower? So it's very simple. I tell clients, give me receipts. They say it's cash. I had one client that was very difficult to deal with. I ultimately rejected the case just because it was one lie after another. But they said, no, we pay in cash. I said, okay. So how come I don't see any ATM withdrawals confirming how much I forgot what the numbers were, but they were pretty high to perk up my ears, let's say $400 a month. And there was no ATM withdrawals to confirm that. So I say, well, there's no ATM withdrawals. So what's the side hustle? Are you getting paid in cash somewhere, $300-400, and then you're just giving that back to the church? It's possible, but I need proof. I'm not going to walk into a 341 hearing, say we donate 15% of the client's income without one check ever being cut to their church. No ATM withdrawals to show the cash withdrawals that are pretend. By the way, that doesn't even prove it's going to the church. So I said, get me a letter from the church. I never got the letter. That pretty much ended the relationship because, like I said, it was one issue with another. Now, what I do want to point out the finger. It's the last one here. I'll point my finger to rental insurance. But obviously, there's life insurance, health insurance, and car insurance. Life insurance, term life, or whole life. Term life has no value until the person passes away, and then the beneficiary receives that. Whole life has a value. You are building up equity in a whole life policy. So if a client has a whole life policy, we might again have issues with exemptions. So if it's a whole life, how much is the cash value? When you find out it's a $15,000-20,000 cash value, then that's going to be an issue with the exemptions. That's not going to be protected. Term life, like I said, there's no value in a term life policy. As a matter of fact, probably every case that you come across where the client is divorced, the client is paying child support, they're probably paying a term life policy until the child turns 18 or children to cover child support in case that person passes away. But whole life, different story. Now, why am I talking about rental insurance? Well, again, people tend to exaggerate and cheat on their taxes, and they do the same with rental insurance policies. So when you look at it, I never personally had a rental insurance policy. I always took the approach, if something happens, what's in here? Clothing and electronics. The clothing got wet. I put it in the washer dryer. I'm good. What do I have? A TV in here? It's not worth me financially to pay for. I could just go buy a new TV. But there are people with rental insurance policies. And so now the issue is, what did they declare on that policy? Are they putting down they have $10,000 in personal property, and yet your schedules say they have $2,000 in personal property? This is going to be alarms for the trustee. Why is there such a big gap in between those two numbers? So you have to review the policy and make sure it matches the assets listed in the bankruptcy petition. Obviously, these two things cannot be true. You cannot insure $10,000 when you only have $2,000 worth of personal property. So make sure to look into that, and you'll see that, because you'll see the deductions are usually small, something like $8 to $20 a month. And you'll see it'll go to whatever company, insurance company. But at that point, just make sure to check to see what's going on and make sure that the client is not lying, because the depending on the trustee, they're going to say, well, you either lied on your insurance policy, that's a felony, or you're lying on your bankruptcy petition, and that's a felony. So which lie is it? And then they're going to go work off of that. So be very, very careful when it comes to rental insurance policies. All right. So as we get close to wrapping up, only got a couple more slides here. Taxes. Make sure if the client is paying taxes, I just pay monthly, so there's no garnishment. I'm also self-employed, so I couldn't be garnished. But if it's being garnished, make sure it's just listed appropriately in Schedule I, and that debt is not duplicated now on Schedule J. Now, most debt is not going to be dischargeable. We know that. But here's what I say with this. Sometimes it's, the client, especially when clients are going through difficult times, they start cutting expenses everywhere. So let's say they're paying the IRS $300 a month, and they say, I need time. I'm trying to get, back on track financially. The IRS doesn't care. They're going to be charging interest. So say, sure, don't pay anything for the next 6 months. The problem is when you now are comparing Schedule I to Schedule J, you have a gap between the two with disposable income. What do? Tell the client to call the IRS again and start making those payments. So maybe before it was $300, but right now you have a gap of $250. Fine, make a payment with the IRS for $200 per month. Keep the disposable income down. So sometimes clients will have to get into a repayment plan just to shrink that up. Now, again, does the trustee know that money is owed to the IRS? Yes, that's listed in the petition. Does the trustee know that they're going to have to pay back the IRS eventually? Yes, but the trustee can only work what is before them at that given moment in time. And in this case, it is clear that there is a gap in income. So the trustee is going to say, sorry, but you're going to Chapter 13. That's why the answer is just decrease that gap. There's no rule that says you can't call the IRS and start paying again to decrease the gap. So do it to keep your client out of a Chapter 13. Now, when it comes to car payments, first start off here. A car lease is what we call an executory contract. There is no ownership interest. I see a lot of times lawyers mess that up, or paralegals. And my answer to them is, do you have an interest financially, any equity build up in your apartment? They say, no, of course not. It's a rental. I said, so is a car lease. There's no difference. The difference is the terminology. You are renting your car for the next amount of years. And as a lease, you have the option. That's why it's called a lease with an option to buy. To maybe buy it at the end of the day when the lease is up, or you can just turn it in and start all over again. But that's the issue. Just make sure that you're not claiming some sort of exemption to it, because there is no exemption. You don't own it. It's just an expense. That's all. That's all it is. Okay. Make sure that the expense is listed. Make sure that it is exempt on Schedule C. And then we have to focus here. What are we going to do with this car? Are we reaffirming it? And we'll talk about that later. But a reaffirmation agreement is just that. You're reaffirming the debt. You are keeping the debt. So everything will stay the same. Payments will stay the same. Is there any law that says you cannot negotiate the terms of a reaffirmation agreement? No. Can you reduce interest on it? Sure, you can negotiate everything. Is the creditor going to do it? Probably not. And in Chapter 13, sometimes creditors are flexible, reducing interest rate, et cetera, to make sure someone qualifies because they don't want to take back in the car. But in the Chapter 7, the chances of renegotiating this debt are slim to none. I've never seen it done personally. But that's all you're doing with a reaffirmation. You're just saying you're going to take the car, you're going to sign a separate paperwork. Some lawyers sign it when we get into that issue. Some avoid it like the plague. I've always signed reaffirmation agreements for my clients. We'll get into those issues later on. The other question is, if they're not keeping it, are they surrendering it? If so, there's going to be a deficiency balance, right? Meaning, there's still $20,000 owed on the car, and this car is only worth $10,000. There's $10,000. Just make sure to list on it's now unsecured debt, by the way. Just make sure to list it as unsecured debt. There's no more car to list as a secured debt, right? There's no asset anymore. That asset is gone. It's now becoming unsecured debt. And just put in their deficiency balance, meaning there's going to be a balance. We don't know what it is. Make it up. It doesn't matter. But just to get that debt out of the way. The other issue is, what if there is equity? Remember, if there's equity, how much equity? Is this something the client can afford? Because if there's equity, then we might have to be focusing on Chapter 13. So with the car, same thing with the home, we have to worry about these issues. Are we keeping it? Are we surrendering it? And are there any equity issues involved? If not, then good, we can move forward and there's no issues, but we have to go through that process. Now, finally, domestic support obligations. Remember, that's alimony and spousal support. You're not getting rid of that in bankruptcy. I just want you to focus on, is there what we call an income deduction order or wage deduction order? If so, it's coming straight out of their paycheck. That is the norm, basically. Make sure that if there isn't, then make sure that it's listed on Schedule J. Make sure it's not listed on I and J. Sometimes for the clients that a lot of times it's just done where they pay directly from their bank account to the state central depository. Central depository is what's called in Florida, but let's just say the depository. And then the spouse that receives it, or the other parent, they usually deduct it with like a debit card type scenario. But again, make sure you'll see those transfers coming out of the bank account. Just make sure that what the client is saying, it all matches up. All right. So we are done with Chapter 17 as we focus on the issue of expenses. Remember to be looking at the petition as you go over the PowerPoints, because that is the best way to see everything at once and to get a better understanding of anything. Any questions or comments, of course, feel free to post them in the comment section below, and I'll be more than happy to respond. All right. Take care, everybody, and get ready when I see you for the next chapter, chapter 18, where I'm going to focus on the statement of financial affairs. I've said many times, the lawyers, we call that SOFA. We're going to go over all the issues of transfers of assets and everything else and how that can affect a bankruptcy case. Take care, everyone, and I'll see you soon.